And after that'll be our cocktail party. So let's meet our next speakers, the last speakers of the day. He's New York educated, but a Bama boy at heart. If you're adverse to his client, like Ricky Bobby's kids, he'll come at you like a spider monkey. Or the offensive line of the Crimson Tide. Either way, you're going down. Introducing Anderson Kill shareholder, Ethan Middlebrooks. Ethan's co-speaker. His research and writing skills are so good that his smooth legal slide tackles take down opponents like an illegal rugby tackle. Please welcome Anderson Kill attorney, James Goodridge. And with that, we are going to be talking about recovery for claims and other liabilities after construction. Gentlemen, the floor is yours.
Working? Yes. Okay. So thank you, everyone. So far today, we've talked a bit about what you do before a construction project and how you manage transferring the risk. And we've talked about risk transfer and how to handle claims that may arise during the life of a construction project. So now James and I want to talk a bit about how you manage and hopefully have succeeded in your risk transfer concerns after construction is completed. And you have especially claims of a construction defect or negligent workmanship that may arise. So as we talk to you today, we kind of want to give you a brief recap about the risk transfer concept and the goals we want to achieve. So now that we've completed construction, we can try to take advantage of that risk transfer. So that includes some about accessing a party's own insurance, be it a developer, be it a general contractor, a construction manager, or a subcontractor. Then also how you access other parties' insurance, which is going to be kind of talking about some additional insured coverage or contractual liability coverage that may exist. So within this, we'll give you a little bit of overview of navigating a commercial general liability policy and some key case law that could apply in that regard. So with that, I will let James get into it a little bit more.
Thank you, Ethan, and thank you all for coming, and thank you for sticking around. We know we are the last thing before you get to cocktails, so we really appreciate this. So as Ethan touched on, today we're talking about proactively managing risk through risk transfer. And as part of that, you'll see, as seen on the slide here, there's a cascading chain of responsibility where starting with the owner to the general contractor, down through all the subs and to suppliers as well. And we will talk about how to access our insurance, how to access their insurance. And so in addition to securing an indemnity agreement in the construction contract, you want to make sure that the terms of that construction contract are calling for you to be named as an additional insured. Additionally, you'll want to make sure that there's language there regarding primary and non-contributory. This functions as the first pay rule. Essentially, that can dictate whether another insurance company or another party's insurance pays before you pay or pays before your insurance company has to pay. Lastly, there is the waiver of subrogation. We can think of this as closing the back door to ensure that the insurance company can't come after you after collecting from someone else.
So with these, we just want to note that while insurance is, of course, different than indemnification in the construction contract, for our purposes now, talking about insurance coverage and maximizing it and maximizing other parties' insurance, that indemnity provision is going to come back in and be very important in trying to achieve coverage under certain contractual liability coverage in the CGL policy.
And so when looking at the CGL policy, you want to be aware of whether we are dealing with ongoing operations or completed operations. Ongoing operations, as the name suggests, that pertains to claims that arise during the project, before the project is completed, before there is substantial completion, and we'll want to contrast those claims with claims that are in the products completed operations hazard. We're going to go through that definition and explain what falls within that further. But within the completed operations coverage, you'll want to make sure you're thinking about timing. That this is where statute of limitations may come into play, or statute of repose. With completed operations, you want to be sure that there is enough coverage to cover the appropriate amount of time after the project is completed. Because with the statute of limitations, you're thinking about when can the claim be brought after it is discovered. With the statute of repose, you're thinking about the ultimate expiration for bringing a claim related to the project. So when reviewing your policy, you need to be thinking about ongoing operations versus completed operations.
In addition, just to add to that, when you're contracting out about additional insured requirements and insurance requirements in the construction contract, that's a consideration that you may want to have a subcontractor or a contractor, depending on what party you are, name you as an additional insured and carry completed operations coverage for a period of years that it corresponds to applicable statutes of limitations, in particular, a negligent statute of limitations. So in New York, that's 3 years. And the reason for that is because frequently when those statute of limitations are about to expire after completion of a construction project, that's usually when lawsuits start getting triggered, because that's when the defects miraculously all get found or allegedly found. And people say, all right, well, you didn't do this right. You did that wrong. Now I'm suffering all these damages inside my condo unit or my condo building now. So now I sue. And you want to be able to trigger that subcontractor's additional insured coverage responsibilities down the line years after the project's been completed. Okay, so now I just want to kind of go over some basics of the CGL policy. And with that, I just want to talk briefly about some of the burdens that you have in showing insurance coverage. And that's important because the courts sometimes don't get that right, as we'll see in some of the case law we talk about. So at its base, in general, it's the policyholder's burden to show a trigger of coverage in an insurance policy. From there, if there's an exclusion that may apply, the burden shifts to the insurance company to say, no, you may have showed that there's a basis to trigger coverage, but now we say an exclusion applies to exclude coverage. Then, if there's an exception to that exclusion, it becomes back to the policyholder to say, no, actually, this exception applies and there's coverage that's restored. That matters here because there are two actual exclusions we want to talk about today. And there's coverages that are in exceptions that are written out to those exclusions that are very applicable to post-construction claims of construction defects. So the key points actually are 4 from the insuring agreement. I don't have to read out the insuring agreement in the standard CGL policy. That's reprinted. You can read that on your own. But the key takeaways for that are the 4 matters that we want to concern ourselves with, which is that there must be property damage that must be caused by an occurrence, which is, in short, usually defined in the policy as an accident. And it must be property damage that occurs during the policy period of the policy at issue, and must be within the coverage territory, which is typically broadly defined to include the entire United States and maybe some other locations. So typically, really what the issues come down to are whether or not an occurrence exists that triggers coverage here. So let's say, for example, we meet that trigger and we show as a policyholder that, yes, there is property damage caused by an occurrence, or at least allegations of that in a lawsuit. Now, insurance company, please provide me defense coverage against these claims of construction defects coverage. Well, typically in a completed operation, an insurance company is going to point to a number of exclusions and say these could all applicably apply to preclude coverage here. A lot of those that they're going to point to are just going to be a lot of, kind of a list that they go through. There's certain ones called the business risk exclusions, which include exclusions J5 and J6 they cite oftentimes for construction projects. Those I don't talk about much we don't talk about here because those really apply to ongoing operations. What we're concerned is more so with exclusion L here, which is an exclusion that's for property damage to your work arising out of it or any part of it included in the product's completed operations hazard. What does that mean? Weird terminology, products completed operations hazard. So that's a term that's defined in the policy to, in short, essentially mean one of 3 definitions that's listed out. But if a project is completed in whole or in part, depending on if it's parceled out to different sections, then it may be a completed operation. Or when part of a project may be completed and put to its intended use by the owner of the project, then it could be a completed operation. So we heard in the last session about the idea of these 2 towers. One could be opened up and one could still be under construction. And that may not be where you want to stay for a hotel, but that's important for insurance purposes because the non-completed portion of the tower could be something that's still subject to issues maybe under builder's risk. The completed portion may be actually in operation, and that could be considered in that portion under a product completed operations coverage for a CGL policy. So it's important for a policyholder to know, or a plaintiff to know in a lawsuit sometimes, or a defendant to know whether or not this definition is met for a product completed operations hazard. You also want to ensure that this coverage exists in a policy. It's typical in CGL policies, but you could tell when you look at a declarations page, you'll see that there's typically a limit for product completed operations hazard. It's an aggregate limit typically, and commonly at least that I see, of $2 million. So $1 million per occurrence policy, $2 million in the general aggregate, $2 million in the product completed operations hazard aggregate. So walking back, if you show that you're in the product completed operations hazard, or we'll call it completed operations for short, then there's a potential exclusion L could apply. However, there's this important exception to exclusion L, which is that there should be coverage if the work performed on your behalf was performed on your behalf by a subcontractor. And that's very significant, although that's disputed as to its applicability by jurisdiction. And that's kind of where courts sometimes screw up the idea of what's an occurrence versus what's an exclusion, because they look at the idea of the exclusionary language as the idea of the coverage trigger there. I'll get to that in a second. I just want to say this key exception came out in 1986, so it's 40 years old this year, so happy 40th birthday, subcontractor exception. All right, so before I turn it back to James, I want to talk a little bit about some, New York case law in particular, because of course we're in New York right now, but also some New Jersey case law on this point. So New York's kind of a hot topic, I guess, if you will, right now, since there is a pending Second Circuit case that just had oral argument on January 5th of this year that deals with claims of alleged negligent or defective workmanship and property damage. I think that what's likely to happen in that case, which is called Burlington Insurance Company. The shorthand name is Skyline Restoration Company, or Skyline Restoration. But I think what's likely to happen there is that the Second Circuit is going to seek or certify questions rather to the New York Court of Appeals and have them decide what the law of New York is. If they don't do that, they're going to take an educated guess at how the Court of Appeals will actually rule here, I think. But based on the oral argument and the questions from the judges, it doesn't sound like they want to take that guess, because in 1994, the Appellate Division First Department issued this case, George A. Fuller, that's a little notorious and a little frustrating, and I think wrongly decided. So that decision dealt with claims of defective construction and whether or not they constituted an occurrence under a CGL policy. Those claims were brought against a general contractor who did engage subcontractors, and it involved claims of water infiltration, amongst others, into a building, and the claims arose after construction. The court there didn't really care at all about the existence of the subcontractor exception, and they essentially expressed concern that if you trigger CGL coverage in this instance for a general contractor whose entire building was their work product, that First Department said, then it would essentially turn the GL policy into a surety bond, and that's not the purpose of the GL policy. So, not so good. It's I think wrongly decided. Insurance companies will frequently cite to it as a basis to deny coverage for a general contractor, and say that if there's any instance of a defect or a claim of a construction defect, that there may not be an occurrence sufficient to trigger coverage even. So you don't even get to those exclusions and exceptions. There are ways around that sometimes where you could argue that the actual occurrence is something more like New Jersey recently pointed out. And I think New Jersey, besides being across the Hudson River, is significant because in the 1980s, New Jersey, through this case called Weedo v. Stony Brook, kind of kicked off the trend of saying defects cannot give rise to coverage because they're not an occurrence. But they revisited that in 2016 in the Cypress Point Condo Association case, where they said, policies have changed since we first looked at this. In 1986, we had that big change. And let's look at this and look how it plays out. So while a construction defect itself may not be an occurrence in New Jersey, they say under their interpretation of that term in the policy, if there's consequential harm that's caused by negligent work, that could be an accident. And if there's property damage as a result of that consequential harm, there could be, it should trigger coverage there. The issue in that Cypress Point case was for the consequential harm, the infiltration of rainwater into a building after construction. That infiltration of water resulted from negligent work at issue.
Yes. So as Ethan has said, you need to make sure you're looking with, it can vary by state. So when you would, once you determine which state's law applies, you need to see how their courts have interpreted an occurrence and property damage within the context of a CGL policy. In Massachusetts, they've approached the issue in a negative standpoint by finding that property damage does not include the cost to repair construction defects to a home. In Lazard, for example, that dealt with a general contractor who was responsible for constructing a home. There were numerous structural, siding, and roof defects discovered during the process of construction. And the question before the court was, do those costs to repair those defects count as seeking damages for property damage within the meaning of the policy? The court found they did not, and the court looked to, in its view, the purpose of CGL policies and whether they should apply to an instance where, in the court's view, the structure is defective, the structure is defectively constructed, whether that can be property damage that the policy was intended to cover. And in Massachusetts, the court found it does not. Pennsylvania's also had a negative result, and you need to be aware of this if you are dealing with a claim arising out of Pennsylvania.
And, we're talking about a jurisdiction that's a little far from here, but I think is important because Texas, as an example, is a jurisdiction that's a little more broadly construed on this issue. And because of, these differing approaches in different jurisdictions, and let me note, the majority approach in the nation is that a defect will, in some fashion, trigger coverage if there's a resulting property damage from a defect, or an alleged defect, or negligent workmanship, however you want to word it. That's really important to the Second Circuit in its deliberations of whether or not they can make the right call in saying, is George A. Fuller the law of the land in New York, or does the New York Court of Appeals need to say it's actually more in line with the majority approach here? So New Jersey, I mentioned, talked about the idea that consequential harm resulting from an alleged construction defect can be an occurrence. Texas and Lamar Holmes took a slightly different approach where they held that the actual defect itself can be the occurrence, which I think is pretty interesting because, you don't contract with someone to come perform work on a property in a construction project to build that project incorrectly. You contract for them to do the job right. Now, if they do it wrong inadvertently, that's negligence. That's an accident. So that's how the Texas court looked at that. That's actually how Florida's looked at that as well. So in Texas, for example, they said that actual claims of defective workmanship itself can be an occurrence under a CGL policy, so long as you still have separate resulting property damage that it was not expected or foreseen by the party performing the work. I just think the second quote is kind of interesting because, also Texas discounted the difference between a surety bond and a CGL policy, which I think is an interesting contrast to how the New York's appellate division is focused on a stated concern that CGL policies do not get converted over to surety type policies.
In addition to assessing whether there's been an occurrence or property damage, you'll also want to consider, especially when you're thinking about tapping into another company's insurance policy, you'll want to think about these two other avenues for coverage. One is the contractual liability coverage. This grows out of an exclusion for contractual liability and the exception within that exclusion. Next, we'll talk about additional coverage, additional insured coverage, which essentially that will work as a backstop to making sure funds are available from your subcontractor, making sure that their commitment in the indemnity agreement can be backstopped by their insurance policy.
So as an initial matter, James just kind of gave a preview of it. And we mentioned earlier that there's certain exceptions to exclusions that give coverage we were concerned about. So within the CGL policy, there is a contractual liability exclusion in the first instance, which is also, I think, important to note because as some courts have recognized, a CGL policy can actually apply to claims of breach of contract, so long as there's a claim that breach of contract relates to bodily injury or property damage. They say that's one reason you have this contractual liability exclusion in place, because the exclusion itself is pretty broad insofar as it's worded that it exclude liability assumed in a contract. Now, there are exceptions that we want to talk about to that exclusion, but essentially at its core, the exclusion seems to be worded to be set up that the CGL policy, while it may apply to certain kinds of breaches of contract, are not going to cover every kind of contractual claim. The CGL insurance company is not going to act and help you out because your benefit of the bargain was breached when it's only an obligation between you and a contracting party. However, when there's certain other instances that such liability assumed in a contract might apply to property damage or bodily injury, there might be coverage. So those are those exceptions arise when there's a duty or obligation that exists in law, such as a tort, or when it exists in certain kinds of contracts, which James will talk about. Never mind, I'm talking about that. In the first instance, as I noted, there's the tort exception, as we call it, to the contractual liability exclusion. So that's pretty straightforward. The contractual liability exclusion does not apply when the insured or the policyholder would have had a liability in the absence of a contract anyway. So, the idea that you learn in law school pretty early on is that there's a zone of foreseeable harm, and anyone in that zone of foreseeable harm that you owe a duty to. If you breach that duty, then you committed a tort. So even if you have a contract in place, it doesn't matter if there's some sort of zone of foreseeable harm implied in law and you breach that legal duty that's implied in law. An example is I've litigated a case where there was a contractual claim at issue where the subcontractor was hired to help kind of dig a trench to lay some sort of piping, I believe, if I remember correctly. And they subcontracted that work out to do the actual digging as opposed to the pipe laying. The subcontractor essentially rammed its digging machine over and over into some power box that's buried underground on Governor's Island, blacking out half the island, causing a lot of delay damages to some construction work that was being done there about 15 years back. So some of the question arose in that instance because the actual underlying claim against our client in the underlying case was only for a breach of contract and the breach of the construction contract because the tort statute limitations had run. Nonetheless, the argument was, well, setting aside the issue of statute of limitations and whether or not that claim could have been brought, there's already a legal duty owed in law aside from the contract because you're expected not to go in and damage someone else's electric box and knock out the power to half of Governor's Island when you're doing your work. The other way that the exceptions to the contractual liability exclusion arise are if the insured or the policyholder assumed the liability in what's called an insured contract, which is a type of contract defined in the policy, provided that the bodily injury or property damage occurs after the execution of that insured contract.
As Ethan mentioned, in addition to the tort exception to contractual liability coverage, there is also the insured contract exception. The insured contract exception in the policy, insured contract will be defined in various ways. For our purposes in a construction context, we were often looking at definition F here, that in that you can break it down to make sure that you want to look at the indemnity agreement that you have with your contractor or your subcontractor, make sure that it provides that you are required to assume the liability of another party. And in addition, in the second sentence here under the definition, it has to pertain to the insured's business, which if it's a roofing company, make sure the liability applies to your work on the roof. As Ethan mentioned, timing is a concern here, and you want to make sure, essentially, the insured contract exception will not apply to liability that arose on Monday if you enter into the insured contract on Tuesday. So you want to make sure that this is applying to claims that arise after you enter the insured contract and claims that arise during the policy period.
And we just want to note that this insured contract coverage is a consideration both for a party as with their own insurance, because their insurance can act as essentially a backup perhaps to an indemnity obligation in a construction agreement. But also it matters for shifting the burden to someone else's insurance because, as Jason mentioned earlier, you could have some mom and pop subcontractors who don't have the funds to actually pay their indemnity obligations. Well, sometimes additional insured obligations, even though they may be in a contract, aren't actually properly met. So you still want to pivot and look to that indemnity obligation. But if that subcontractor cannot pay their indemnity obligation, then at least you hope that there's a trigger of coverage under the insured contract exception to the contractual liability exclusion, such that that subcontractor's own CGL policy backstops and pays the indemnity obligation on behalf of that subcontractor.
In addition, as we mentioned, in addition to the contractual liability coverage, there is also an additional insured coverage. As Ethan touched on, additional insured, you essentially are you are entitled, with limited exception, to the rights that are guaranteed to the named insured. However, it's important that you review the language specifically providing for the additional insured coverage to determine the scope of that coverage.
So why do we want additional insured coverage? Well, there's some good benefits. It supplements the contractual indemnification obligations, and it could be broader than the limitations that might exist in law or otherwise in those contractual indemnification obligations that exist. For example, it may go beyond an additional insured sole negligence, depending on the jurisdiction you're in. It also allows defense coverage to be tapped into by someone else's insurance. Why does that matter to you as the policyholder if your insurance company is not defending you, even though they have an obligation? Well, if they're not involved, then it may affect your bottom line, your loss runs, your premiums for the next year. If ultimately you have another party paying defense costs and hopefully paying any kind of indemnification costs under that CGL policy down the line. On top of that, if there are deductibles or self-insured retentions that may exist on the policy to tap into defense costs, you as an additional insured aren't responsible for paying that. It's going to be the named insured who's typically responsible to handle that. So, I mentioned that sometimes additional insured coverage may be called for in a construction contract, but it may not be there. So you want to make sure it's there. So how do you determine whether or not you have additional insured coverage? But ideally, you're going to have a copy of the policy. As Jason suggested, a best practice is ask for a copy of a policy via the contract before a project begins. Assuming you actually get that policy, because sometimes parties don't want to give up copies of their policies, you want to review it and you want to see what kinds of additional insured endorsements may be in that policy. This includes ISO forms. So, I don't know if everyone's familiar with ISO, but both of us keep dropping that term, but it's the Insured Services Office. So, or organization, excuse me. So they write standard form policies, which are usually the basis of otherwise what are called manuscript forms, which are forms that are written by a certain insurance policy for a certain policy holder. So you want to see what the additional insured endorsement itself actually looks like for the language in that additional insured endorsement. So here we just have some sample ISO forms, both for the completed and for the ongoing operations, just, it's a refresher for what it looks like. So this is the form CG 2010, which is for ongoing operations, and CG 2037. So I just want to quickly touch on the differences in those because our focus, of course, is on completed operations. The 2010 focuses on the idea of acts or emissions of a party that took place for the ongoing operations. However, for the completed operation, the focus is on whether or not the additional insured is being blamed and faces some liability as a result of the work of the actual named insured and as a basis to trigger the additional insured coverage. So again, completed operations focuses on the whole idea of your work as it's defined in the policy. This is a really fun topic, talking about evolution of standard ISO forms. So I'll go through it pretty fast. But more or less on these two types of forms, it started back in 1985 with a very broad form agreement that covered both the ongoing operations as well as the completed operations, with extremely broad language of arising out of. As Josh mentioned earlier today in our first presentation, the term arising out of is construed to give a very broad causal connection. So that kind of form, someone could still call for that kind of form to be acquired in a construction contract. In theory, it could be purchased, but in reality, it's probably not going to be able to be purchased for anything cheap. But from that time forward, everything got narrower and narrower. So in 1993, the idea of a completed operations coverage in a standard ISO AI form got cut out. It's only ongoing operations. 2001, it got added back in. So now you have this idea of a separate 2037 form that has an additional insured coverage that could exist with there's a claim of liability arising out of the named insured or the subcontractor or whatever's work. Then it kind of narrows a little bit more from there. 2004, the idea of the arising out of language gets narrower and becomes an idea of proximal causation, where the language shifts to where it has to be property damage caused in whole or in part by the work of the actual named insured. From there, it got even narrower, where there is language that puts in that looks outside just the insurance policy itself to the construction contract and says essentially that the actual coverage afforded to additional insured could be limited by what the construction contract says, including that the limits that will be applied will either be the lesser of what it says in the policy, like I mentioned, $1 million per occurrence typically, or it could be whatever the contract says if that's lesser. If the contract says name me as an additional insured for $500,000 per occurrence, insurance companies can say we have no obligation to additional insured beyond $500,000. The named insured, however, gets that full benefit of the bargain of that $1 million of limits under the policy.
In addition to that evolution, it's important to consider the somewhat rare instance where the policy will include a schedule of entities that are additional insureds. However, one of those entities might not have a indemnity agreement with the named insured. Often, if simply being listed in the schedule is enough. However, some policies have required that there be an addition. Essentially, the entity listed as an additional insured must have a separate contract with the named insured. This does not reflect the majority of additional insured policies, but it's something to keep an eye out. As Ethan mentioned, there are multiple ways to confirm that you have additional insured coverage. You'll want to check the certification of insurance. However, best practices do not stop there. Try and see a copy of the policy itself. And if you can't see that, try and at least see the declarations of the policy.
Yeah, we heard some good warning early on about while certificate of insurance is a common practice to check, it's not always accurate. So it may be evidence of what insurance company may have sold a policy to what policyholder, but there's no guarantee that because it says you're an additional insured to that policy that you actually are. This is something that I've seen in practice a lot. And maybe that you are an additional insured to that policy, but only for ongoing operations and not completed operations. Oops. I hit this part.
One of the major benefits of additional insured coverage is the ability to access defense coverage from the additional insuring company. This often defense coverage will be it's first off, the duty to defend is broader than the duty to indemnify. And so often you'll find that by obtaining defense coverage, that will be the brunt of what the expenses are sometimes.
Right. Right. A key contrast about defense coverage for additional insured two versus the contractual liability coverage is that if an insurance company is backstopping and indemnifying subcontractors' indemnification obligation, which may include defense, but you're not providing additional insured defense coverage, that contractual liability insured contract coverage actually erodes the property limits under a standard CGL policy, meaning that there's less money left over to pay indemnification. But under additional insured endorsements, is typically the standard duty to defend under the CGL policy, which is outside the policy limits, or meaning that the insurance company is going to pay defense costs without it eroding the actual limits of liability of the policy, which is pretty important because in a big construction defects case, sometimes the plaintiff doesn't really care who pays what. They look at one big pot of money and they say, so what? There are 15 defendants in this case. Money's fungible. Like pay me $18 million. I don't care who pays it. So ideally you want to have as much insurance money left over in that pot to be paid in as possible and settle the claims. So again, for that defense coverage though, you got to show that the potential liability, if you're to be an additional insured, that your potential liability was caused in whole or in part by the named insured's work or operations typically. So how do you do that? That can come up as kind of an issue that has to be managed, because it's not uncommon that if you're a general contractor or construction manager, a property owner, if they buy a property after construction is completed, they're not going to know all the parties who did work. They're not going to know the subcontractors. So who's going to be sued? Maybe a developer, and then you as a construction manager or general contractor. So how do you suddenly trigger everyone else's additional insured obligations? Well, at times, and this has been done, what you see on both sides of the Hudson and supported in coverage claims, you can do self-help essentially. You can make a third-party action. Don't forget your timeliness now under the Void Act, but you can make a third-party action naming all the subcontractors who actually may be implicated here and say, look, this actual main complaint says that like the foundation was built badly, or the garages are built badly, the roof is bad, there's terrible like curtain walls, so now there's all this water infiltration into this building and there's damage. Well, I'm being blamed, but you subcontractor did the foundation work, you did the curtain wall, you did the roof. So as you name them these third-party complaints, that could be a basis sufficient to trigger coverage on that third-party complaint, saying that at least for defense coverage purposes, there are allegations that that subcontractor through their work caused in whole or in part the actual construction manager's potential liability. You can also look at extrinsic evidence in certain jurisdictions. New York is supposed to follow the rule that a policyholder can prove a duty to defend via extrinsic evidence. So here, you can look at ideas like what Jason talked about earlier, the scope of work. What's the scope of work defined in certain construction contracts? Who's supposed to do what work? That may be a basis to point out. Jaron mentioned the idea of whoever has the most documentation wins. Documentation also matters for GL coverage here, for additional insured coverage, to show who does what, and even showing up the idea of ultimately indemnity coverage. So the underlying defense counsel is going to be interested in that documentation, such as the daily reports, who did what work when, and who might have caused something wrong potentially in whole or in part. So just a warning though, also, many insurance companies who do defend an additional insured reserve the right to deny coverage for indemnity payments ultimately when you hit that point. So that's often a point of contention at settlement time. Again, sometimes money may be fungible to one party or to a plaintiff, but it's not necessarily to the insurance companies, of course, paying. So one other point I kind of want to talk about the defense aspects is other insurance provisions. James talked about the idea that you want to have primary and non-contributory as part of your construction contract additional insured obligations. That can matter here because in a lot of CGL policies and other policies, you have other insurance provisions. So typically in a CGL policy, there'll be these statements that, a policy, if it's a primary level policy, will act as primary except where it's supposed to act as insurance. So, as excess. So oftentimes under the language of this provision, it will be excess if there's some basis for some other insurance that applies, it's supposed to be primary. So if there's an additional insured obligation that's supposed to be primary and non-contributory by another policy, then your own policy sits excess to that. So again, you let that additional insured coverage kick in and apply to you first and have your own insurance as the backstop. A little war story is that sometimes you as a policyholder can try to deputize your own insurance company to chase these other insurance companies down and say, look, I owe my named insured an obligation to defend. They're the ones named as the main defendant in the complaint, the construction managers say. However, you Admiral Insurance, you owe an insurance obligation to them as an additional insured. So I'm going to chase you down because under the language of these policies, you go primary and I go excess. So start paying. So we might wrap a little early, which I don't think anyone's going to complain at the end of the day. So some key takeaways that I think are that you got to look at the jurisdiction you're in, but remember the trigger of coverage for construction defects in a GL policy is going to always be in the starting of the insuring agreement. So just because the claim might revolve around the idea of a defective work or defective construction, the occurrence need not or maybe cannot, depending on the jurisdiction you're in, be a construction defect. It may be something like water infiltration. With that in mind, also you want to be mindful when there's a completed operation of the subcontractor exception to the year work exclusion and the applicable case law that deals with that exception.
And as part of proactively managing your risk, you'll want to make sure you set up a path for yourself to tap into the insurance of other parties. And when you're doing that, you'll want to look at contractual liability coverage in addition, including those two exceptions that we discussed and additional insured coverage.
That was great. Thank you, gentlemen. We are now at the end of the presentations. Well, we hope that everything today has been helpful and informative. It's been our pleasure to present this. We look forward to doing so again. There's an email address up there, and you probably have the contact information along the way for a bunch of us. And if there are any suggestions or comments you've got about this conference, please share them with us. We'll do this again, and we want to make it better. So tell us how we can make it better. Let's see. Yeah, in the meantime, please think of us and call on us to evaluate any legal situation you may encounter or any time that you think we might be able to be of assistance to you. We want to thank our excellent Anderson Kill staff, especially the folks in marketing who did a tremendous job. Wanu is in the back. Chris and Devin, come on in, please. So we've also got two gentlemen that also helped us out, Chris Brand and Devin McKay and Wanu Owasheni. So thank you very much to the Anderson Kill Marketing Department. We couldn't have done this without them. So we've got refreshments and networking to follow, and we are on schedule, folks. So please have a great evening. Enjoy the reception, and please get to know some of the Anderson Kill lawyers you might not yet know. Dennis, any closing comments? Sorry, I didn't mean to wrap it.
Surprisingly good here.